Order. The draft Digital Markets Competition and Consumers Act 2024 Consequential Amendments Regulations 2025.
I call the Minister to move the motion.
I beg to move that the Digital Markets Competition and Consumer Act 2024 Consequential Amendments Regulations 2025, which were laid and draft before this House on the 18th of December 2024, be approved. Good evening, Mrs Harris and Oswald Dwyer. It's a pleasure to see you in the chair this evening. I hopefully won't detain colleagues for too long. This regulation is quite straightforward. It relates to the Digital Markets Competition and Consumers Act 2024, which received royal assent in May of that year. This instrument makes amendments to legislation in consequence of Parts 3, 4 and Chapter 2 of Part 5 of the Act. Part 3 of the Act updates and strengthens enforcement of consumer protection law. Part 4 updates the legislative framework on consumer protections against unfair trading, introduces substantive new consumer rights in relation to subscription contracts and consumer savings schemes, and introduces reforms to alternative dispute resolution. And Chapter 2 of Part 5 of the Act allows UK regulators to provide investigative assistance to overseas regulators with corresponding functions in relation to competition, consumer protection and digital markets. To ensure the provisions of the Act take effect as Parliament intended, it is necessary to make consequential amendments to the enactments listed in the schedule to the regulations. These are relatively minor changes that do not materially alter policy that are needed to ensure the seamless functioning of consumer protection law and enforcement. The amendments within the instrument fall into three broad categories. Firstly, they extend the application of legislative provisions that permit public authorities to share certain information with consumer enforcers. At present, persons or bodies that gather information using powers under certain statutes may share that information to facilitate consumer enforcement, consumer protection or overseas investigatory assistance in certain circumstances. This sharing is permitted by sections of the relevant statutes, which I will refer to as information gateways. These information gateways list the consumer protection legislation in relation to which information may be shared. For example, where Ofcom gathers information using powers in the Telecommunications Act 1984, the information gateway in section 101 of that Act permits it to share that information with the Competition and Markets Authority for the purposes of enforcement of, amongst other things, the consumer protection from unfair trading regulations of 2008. And as I've said already, the DMCC Act introduces a new consumer enforcement framework, new and updated consumer protections and new provisions on investigative assistance to overseas regulators. It is therefore necessary to add reference to these provisions to the information gateways in various statutes. Were these provisions not to be updated, the current approach whereby information may be shared by public bodies to facilitate consumer protection would be unavailable in respect of the new provisions in the DMCC Act. This would compromise consumer protection, which could of course lead to consumer harm. The second group of amendments is to Schedule 5 of the Consumer Rights Act 2015. This schedule sets out the investigatory powers of consumer law enforcers. These amendments ensure that the CMA can use relevant investigatory powers to monitor compliance with certain of its new direct enforcement notices, as it may do in relation to other direct or court enforcement orders. For example, at present, the CMA can require a person to provide information for the purposes of ascertaining whether a person is complying with a court enforcement order against them. This enables the CMA to ensure enforcement orders are being complied with, and therefore the enforcement proceedings are having the desired effect. Under the DMCC Act, the CMA will also be able to use investigatory powers to monitor compliance with certain of its direct enforcement functions. The Act introduces a new power for the CMA to give final enforcement notices for failing to respond to an information notice alongside its other direct enforcement powers. The amendments in these regulations are necessary to ensure that the CMA is empowered to monitor compliance with this new power in the same way as in relation to the rest of the court-based and direct enforcement regime. And finally, this instrument updates references to consumer laws that have been repealed and replaced by the Act with references to the new relevant provisions introduced. These amendments again do not materially change the policy or effect of the underlying law. They simply keep the statute book up to date in the way we'd all want to see. So I hope it's clear from my remarks the intention of these regulations is to update and maintain the frameworks that underpin consumer law and its enforcement to ensure that the consumer reforms can be introduced seamlessly and with no inadvertent detriment to consumers. I invite the House to support the passage of this instrument and commend it to the House.
The question is that the committee has considered the draft Digital Markets Competition and Consumers Act 2024 Consequential Amendments Regulations 2025. Shadow Minister Greg Smith.
Thank you, Mrs Harris. It's a pleasure to serve under your chairmanship. I'm pleased to see that this statutory instrument builds on the good work of the previous Conservative government through the Digital Markets Competition and Consumers Act, which received royal assent in May 2024 under the stewardship of my right honourable friend, the Leader of the Opposition. As the Minister said, this instrument makes amendments to legislation, consequence of Part 3, Part 4 and Chapter 2 of Part 5 of the Digital Markets Competition and Consumers Act 2024, which I shall refer to as the DMCCA from henceforth. Part 3 of the DMCCA updates powers to investigate and enforce consumer protection law. Part 4 of the Act gives consumers protections in respect of unfair commercial practices, subscription contracts and prepayments to savings schemes, and regulates the provision of alternative dispute resolution for consumer contract disputes. Chapter 2 of Part 5 confers statutory authority for UK regulators to provide investigative assistance to overseas regulators who have functions corresponding to UK regulators in relation to competition, consumer protection and digital markets. This instrument updates references across the statute book to the legislation which Parts 3 and 4 of the Act replace, ensuring that regulators and others can disclose information to enable consumer enforcers to investigate and enforce breaches of the consumer protection. So, Ms Harris, I welcome the measures taken by the government in this statutory instrument, which, as I said, builds on the work of the previous government. However, given the importance of the legislation, I would like to ask the Minister to provide some further clarity in a couple of particular areas. This instrument updates various pieces of legislation which restrict the disclosure of information to allow for disclosure of information for the purposes of Part 4 of the DMCCA. The instrument also amends the Water Resources Act 1991 to allow disclosure for the purposes of Parts 3 and 4 and Chapter 2 of Part 5 of the Act. So, could the Minister elaborate on what protections are in place to ensure that information sharing is handled appropriately and remains secure? And perhaps on a little bit more of a political note, Mrs Harris, my second question is that one of the DMCCA's purposes is to provide consumers with protections against subscription traps. However, as the Minister well knows, as we spent a long time on the Employment Rights Bill Committee together, the Employment Rights Bill would automatically opt in trade union members to a political fund unless they expressly opt out. So could the Minister clarify what the government position on subscription traps is, and is the government holding businesses and trade unions to different standards?
Minister Mathers.
I thank the Shadow Minister for his second bite of the cherry on the subscription traps and trade union subscriptions arguments. Just in terms of the data issue, this is in basically the same safeguards as have always been in place. That is not going to change. It's just the legislative envelope that has been updated, so those protections will still be there. But in terms of the political point that the Shadow Minister has made, he will of course be aware that membership of a trade union is not akin to a Netflix subscription. It is it's being part of an important industrial body, a society that represents you at work. It provides collective bargaining in appropriate circumstances. It is not like ordering a film or something on Amazon. It is completely different, and it is our contention that this is about people having rights as consumers, not rights as workers, and that is why we make the distinction. So, on that note, I'm grateful, I think, for the support of the House and beg to move that the regulations be approved.
The question is that the committee has considered the draft Digital Markets Competition and Consumers Act 2024 Consequential Amendments Regulations 2025. As many of their opinions say aye, of the contrary no, I think the ayes have it. The ayes have it. Order, order.